Start. Keeping the aforesaid principles in view, when we examine the facts of this case and the concurrent findings of the trial court and the high court, we find no substance in the contentions urged by learned counsel for the appellant. Full stop. It is amply established on record that the deceased children, aged 9 years and 6 years respectively, died an unnatural death, and though the bodies were retrieved from canal, it had not been a case of their drowning, but, as specifically proved by the post-mortem reports and the testimony of PW-14, the cause of their death had been asphyxia as a result of manual strangulation. Full stop. There is nothing on record to disbelieve the testimony of PW-14, full stop. The only line of cross-examination of this witness had been as if he did not carry out post-mortem examination of the dead bodies of the victim children, and that he manipulated the report at the instance of police, full stop. We are unable to find any substance or logic in this line of cross examination. Full stop. The fact that the dead bodies of the victim children were indeed retrieved from canal is hardly a matter of doubt and has indeed been established in the testimony of PW-18, PW-17, as also other private witnesses, including the relatives of the appellant and his wife. Full stop. It had been too far stretched to suggest that the medical officer did not examine the dead bodies of the victim children, as sent to him by the investigating officer, or his having manipulated the report. Full stop. The evidence available on record, taken as a whole, leaves nothing to doubt that the victim children had been subjected to manual strangulation which resulted in their death. Full stop. Obviously, their dead bodies were thereafter thrown in the canal to project as if it were a case of drowning. Full stop. The fact that the deceased children, when alive, were lastly in the company of the appellant alone is also not of much doubt or debate. Full stop. In this regard, even before looking at any other evidence, suffice it to notice that PW-9, wife of the appellant, who otherwise did not support the prosecution case, clearly stated the crucial fact that on the day of incident, the children were left by her with the appellant. Full stop. She indeed stated that single inverted comma on the day of incident, I went to the house of my maternal uncle as my nanny was ill, leaving my both the sons with their father slash accused, single inverted comma close, full stop. She later on received the call from the police station about demise of her sons, full stop. Therefore, it remains rather undeniable that the deceased children were lastly in the company of the appellant alone, full stop. In regard to the chain of circumstances in the present case, statements of three independent witnesses, PW-1 delivery boy at the petrol pump, as also PW-4 and PW-6, personnel in charge at the water treatment plant assume significance, who testified to the facts that the appellant did visit them immediately after the incident and specifically stated before them that his sons had accidentally fallen into the canal. Full stop.